Introducing the legal test for workplace discrimination. The three-part test for discrimination was established by the Supreme Court of Canada after the Marion decision. They established that the three-part test was in such: an organization or institution must establish on a balance of probabilities that the standard, factor, requirement, or rule was one, adopted for a purpose or goal that is rationally connected to the function being performed, and two, adopted in good faith in the belief that it was needed to fulfill the purpose or goal, and three, was reasonably necessary to accomplish its purpose or goal because it is impossible to accommodate the claimant without undue hardship. When I watched the video, that was just a short clip explaining the story and the case that Tawny Marion went through, I thought that instantly that she was such a brave and courageous woman to recognize and speak clearly, especially at a time back then, about being a victim of sexual discrimination in the workplace, was a very brave thing. And I thank her, as I'm sure many other women would too, for moving forward and fighting it. And not just fighting it and being modest about it. She was so aggressive about it that even after she won and the government chose to appeal that decision, she didn't give up. And in fact, she fought harder. This had to have been a very difficult thing for her to go through. And I think that she is a woman that should be remembered in history for changing the way that we evaluate how discrimination is justified and or shall I not say justified, but rectified. This was a case that really hit home with me, and I think I'll leave it at that and move on to scenario 2. In this scenario, Sarah is a salon owner, and she's advertising because she's looking to hire more hairdressers. Naya comes for an interview, and they decide that she's going to take the position. During no time in the interview, though, does Naya let Sarah know that she must wear her headpiece, and that is something that's not optional for her because of her religion. And the issue arises as, would this be grounds for discrimination? Based on the Human Rights Code, I feel that this is a fight that Naya would not win. I don't feel that it's discrimination. Sarah isn't doing this because she's got any problems with somebody's religion or the things that they practice in their personal life. The reason that she is pertinent and insistent on that nobody wears a hat, a headpiece, any sort of coverage on their head is because it's a salon with hairdressers. And when her clients come in, she wants them to see what different products essentially are available for them. Every time one of the girls that are males that are in the salon there to cut hair, or even the people that are just there to be administrative support or whatever their job might be, every time that any customer is looking at them, they're seeing the way that they style their hair and the way it's cut, and it can create business because somebody else might want that look. And it also creates a professional atmosphere of what their product, what their standards and expectation is within the salon. When we ask what arguments do you anticipate the employer will make around the undue hardship, I think what I've just discussed there covers that. And I think that it is kind of not fair. It's pushing it too far. I'm a firm believer that nobody's religion or religious rituals or beliefs should be discriminated, or nobody should have to suffer any sort of disrespect or be uncomfortable about who they are. But in this situation, I feel that this isn't anything to do with that. This situation is no different, in my opinion, than if you were working at a manufacturing facility and it was a requirement that you wear steel toe boots or you wear a hard hat or safety equipment. I feel that this is just part of the criteria for what you need to have to work at this place of business. It would be no different as well as saying to your employees that you cannot wear anything that expresses any sort of opinion on your t-shirt or on your clothing. And also in your conversation with your clients, when you're cutting their hair, you don't share political or um, different opinions on social discussions or events. I think that this would be, in my eyes, somebody screaming, this is a matter of discrimination, without actually thinking about what they're fighting for and what they feel like. What does she think is really being taken from her? What does she feel is she's really being subjected to? I feel that maybe she's even discriminative to the business owner. Um, but that's just my perspective. And now I will read to you scenario 3, which was my part of the assignment to contribute. In scenario 3, Suzanne owns a small restaurant. Roberta, the restaurant chef, is an excellent cook, but she is very temperamental. She becomes angry and abusive with all her kitchen staff and waiters over the slightest mistakes. It has reached the point that many staff members dread working with her. Suzanne has spoken to Roberta about this issue many times over the course of years. It is getting worse, and when she approaches Roberta about it, she simply tells her that she cannot tolerate incompetence among the staff and that shouting and yelling at them is just a way of her coping with stress. Suzanne has decided that enough is enough and she's going to terminate Roberta's employment. Roberta is a large person and no one realized that she was pregnant. The day after Roberta told Suzanne that she was 7 months pregnant, Suzanne fired her. Later, Suzanne said the pregnancy had nothing to do with the firing. It was just an unhappy coincidence. In this scenario, I've been asked, under Ontario's employment standards legislation, how many weeks' notice or pay in lieu of notice is owing to somebody with Roberta's length of service who is terminated. So somebody that's in Roberta's has put in Roberta's length of service and they've been terminated would be entitled to 7 weeks pay in lieu of notice or 7 weeks notice. Roberta had 7.5 weeks, but it stays at the 7 weeks pay in lieu of notice or the 7 weeks notice until you actually reach the 8-year mark. The next question is it possible that Suzanne's restaurant could be liable to Roberta for statutory severance pay in these circumstances? No, Suzanne's restaurant would not be liable or responsible for any severance, as her salary was under the $2.5 million threshold at $850,000 for the year. And she also was beneath the threshold for the amount of employees she had. She was under the amount of 50 employees in her business. So she would not have to pay any severance. Question 3, in your opinion, is it likely that a court would find that Suzanne had just cause under the common law to terminate Roberta's employment? In my opinion, Suzanne absolutely had just cause. She spoke to Roberta several times
about the nature of how she was treating the staff. And it was totally disregarded, and she was disrespected each time she did approach Roberta about it. She just dismissed it and gave it no importance, treated it as though it was not relevant. So those grounds there would be insolence and insubordination. So Suzanne had total just cause under the common law to be able to terminate her employment. The only things that her timing, of course, was not the best, being that it was the very day after that Roberta had told her she was 7 months pregnant. However, the incidents and the issues that she carried with Roberta had carried on for quite some time prior, and she has an abundance of employees that would be able to testify to that. The only other comment that I have on that is throughout this scenario, we don't hear of her documenting any of her attempts of trying to resolve the issue with Roberta. If she had done that, then this would have been clear cut, black and white, without a doubt, just cause. I still believe that it is, but that she does have just cause. However, in my recommendation, the documentation would have made that more bulletproof. Question 4. Suzanne wants to avoid a lawsuit, so she decides that she will offer Roberta a package. In your opinion, what would be a reasonable offer in these circumstances? So, in my opinion, and as I previously was a business owner with several employees, in this circumstance, in the restaurant scenario of Suzanne's, I would offer Roberta actually 7.5 weeks pay in lieu of notice, which would be, she's only entitled to 7, but I would offer the 7.5. And it speaks in the scenario of the restaurant spending $2,000 a year for special chef's knives that were used by Roberta only for her work in the kitchen. I feel like that would probably be like a bit of a sentimental tool to Roberta. So I would offer the 7.5 years, or 7.5 weeks in pay in lieu of notice. And I would also offer to tell her she could take the knives that she's grown accustomed to with her. And I would note that there would be no severance that she would be entitled to in the circumstances in the section of the Standard Act. And hope that she would settle amicably. Thank you.
And scenario 4. This is a really sad scenario. It's a scenario of wrongful dismissal with a gentleman by the name of Ethan, who was 48 years old and had worked at a company called Happy Hardware for 18 years. He was a supervisor, and out of nowhere, a sexual harassment case was lodged against him. His employer let him go, told him that basically not very much at all, didn't have much of an explanation, even so much as insinuated without really getting Ethan's side of the story, what had happened. There's so many things that went wrong here. There was clearly no policies, there's no procedures, there's no sexual harassment training. He was very unjustly let go. And I believe that the company totally acted in bad faith. The jury providing Ethan with what they awarded him, the 24 months of reasonable notice damages, aggravated damages of $200,000, and punitive damages of $300,000. That, yeah, it seems like a lot of money, but a reputation is something, especially at 48 years old, you've spent a long time to build. And once you have a reputation like that, even if it becomes cleared, it is pretty hard to change people's thinking. As from that point out, sure, some will believe that Ethan was innocent, but there will be many that, even if they say they do, they're going to question the circumstance, and they're always going to be hesitant. His credibility has been tainted, likely forever. So for that, I feel that this probably doesn't justify things enough, and I believe that there's should be something pushed onto the employer more than the 24 months of reasonable notice. They were totally in bad faith and didn't protect Ethan as an employee, as they were protecting the person that alleged the sexual harassment. Very unjust, unfair, and I believe that the employer should have gone through a lot more ramifications for what happened in this scenario.